Here's the only reason why I'm going to say, and I can't say this.
I hate Chuck E. Cheese because I make the kids, like, I bring the kids with me.
And then the nicest some of the students are saying it, and I don't think it's common.
The kids are always sick, the ones I nanny. I mean, they're always sick, and I always end up catching it. You know, when they had this summer school, I told them that I would rather take a week with no pay than be in your house and house. I was like, why am I telling my boyfriend? I'm like,
So in the writing class, she's one of the teachers, the woman.
elevators, I'm like, no, because you use your fingers, knuckles, you know, and now he does it, it's like, oh man, I was like, what have you done to me?
I'm sorry. Zero and like
Right in the middle.
I do all that knuckles for
So the other day I assigned sides and it looks like I have a lot of people on the state side.
I did my family, I did my homework at state, good thing I wrote family too.
We have a real lot of them.
I'm family, but I forgot.
So you should be sitting here. No?
Right over here, yeah.
I'm the
divided.
last state.
Oh, you're the dividing, I forgot, I'm sorry. You're, Laura, who do you represent?
I'm state,
Okay.
and that is the last state.
Okay.
That's what did my homework.
State.
Oh, man.
Okay, awesome. And, you are joining us today, which is
Yes,
great.
I'm from the online
No, I
class.
wrote
That's
down state
awesome.
everything, even
I had the
underlined.
ability to catch the class today and wanted to join.
I'll assign Todd to, family too then.
Yeah, we didn't have very many on families.
Okay, so Nicole, Todd, Amanda,
And the other.
and the other Amanda, if she shows, whatever questions or arguments you're making, you're gonna make from the family's, point of view. Okay. Under instructions, this is the first time we're doing it today, so we have the 4 cases, Meyer, 5 cases, Meyer, Pierce, Prince, Yoder, and Truxell v. Granville.
I felt like Shoxel didn't have anything to do with the other cases.
It's a much later, it doesn't, but it's a much later case on family rights. So as I explained first class, a lot of these early Supreme Court cases are pretty much, you know, family rights, family versus state, with children not having a specific voice in the respect that they don't have, you know, counsel representing them. But I will still ask for, you know, children's counsel today, you know, what particular arguments that the children's counsel might have been making in those cases. And you probably have already have seen as well that in some of the cases that they're not necessarily, you know, family, teachers, et cetera, schools are also petitioners or respondents in these early cases. So what I'd like to do is this. So we start with Meyer v. Nebraska, and I'm going to ask for a volunteer from the family side to represent Meyer, remember the teacher in that case, that could make the argument before the Supreme Court, and then a volunteer from the state side for the state of Nebraska, all right? And the rest of us, including myself, you can take the cue from me, can ask these people questions, much like the Supreme Court, the SJC, appellate level courts ask counsel questions. Jim, where are you sitting? Because I can't see you. Do you represent the family? Did I assign you to the family the other day?
Yes, you are family.
You are.
Okay, you can stay there, it's okay, I'll move over a little bit. Or just move down towards the wall a tiny bit, and then I can actually
Todd's
see your
afraid
face.
I'm gonna make him sick, so he wants me to stay away from him.
Oh,
Oh, you're sick.
is
Stay
that
over
what you
there.
said, Todd? You
Stay
said,
over
Jim,
there.
don't come near me? All right, fine, Jim, stay where you are. Stay away from all of us.
I'm trying. You know,
Because I already had it, I don't want to get it again.
You know, there are several students that are like frickin' frack. I'm frick, he's frack. And I'm just like, you gotta keep your distance.
But how sick are you? Really sick?
How sick are you? What a question.
We should just like
He's
stay
worried
in a
about his
bubble over
brain.
there.
I just get out of the boat.
Okay, so, Nicole, did you say before that you prepped for the family?
I I did all of them, but I prepped for state, but I'm prepped for family too.
Okay, so why don't we start with you as
Okay.
the counsel for Meyer here?
Okay.
And then I need a volunteer for the state,
I'll just stay.
and Laura State. Okay, fine, and you're right next to each other. So the way we're gonna do this is, Nicole represents the appellant Meyer, so she's gonna go first. And as you would have in an oral argument before the court, give us sort of like a procedural statement first, why you're here, how it is you came from the lower court, and then, what questions of law do you want, this court to resolve. So we'll allow her to do a little introductory thing like that first. And then if you want to ask her a question, and I don't know how much discourse you'll be doing for this first class, but if it gets to be, there's too many asking at once, you'll raise your hand. Other than that, feel free to just, interrupt her at any time and say, counsel, blah, 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 and whatever question you'd like to ask. So the rest of us are judges, okay? Yeah.
Interesting concept.
Yes, yes. So
Okay.
you ask judge-type questions, right? Not lawyer kinds of questions. But judges are lawyers too, so. All right, Nicole, are you ready?
I hope so.
Okay.
Okay. Do you want me to stand up?
You don't have to, because I think we're in a room where you're gonna project anyway, you need to for the online people, so
Okay.
you're fine where you are.
Okay. We are here this morning because the plaintiff was convicted in the district court for Hamilton County, because on May 25th, 1920, while he was an instructor.
And so the plaintiff is who, your client, counsel?
He's an instructor.
Okay, your client, correct?
Yes, my
Okay.
client is the instructor at the Zion Chile School, where he allegedly unlawfully taught the subject of reading in the German language to a student who had not passed successfully 8th grade. So,
And that's why you're here, counsel?
that's why I'm here.
Okay, continue.
Okay. The Supreme Court affirmed his conviction because the offense was the direct and intentional teaching of the German language, which was against the law, stating that no one should teach any language in the state besides English to a child who has not successfully passed 8th grade.
So that's the statute that we are considering today, correct?
Mhm.
Can you restate the statute again?
No one should teach any other language except English to a child who has not successfully passed 8th grade.
Okay.
So English should be their native tongue. So the issue before the court is whether the statute, as applied, is unreasonably infringing on the liberty guaranteed to my client in the 14th Amendment.
So what sort of right does your client, a teacher, have?
The teacher has the right to educate children, and the parents consent to that when they send the children to the school to be taught by my client.
So if, guys, by the way, I'll keep asking, but just butt in and feel free to ask the questions as well. So that's the nature of 14th Amendment? Is that what your client is
Oh, the
asserting?
14th Amendment states that they have a right to be heard when their liberty and their property and the other rights in that nature have been taken away
So
without.
precisely what right does Meyer have? Is it life, liberty, or property?
I think it's liberty, no?
And how is it liberty?
The liberty to teach what he wants to teach to the children as an instructor in the school.
So here's my another question that I have. Doesn't the state have an interest, though, in looking at this statute, in promoting what we call civic development by inhibiting educating the young in foreign language before they could learn English, American ideals?
The state wants to improve the quality of its citizens physically, mentally, and morally. However, there is nothing morally wrong, physically or mentally wrong with teaching a child a different language. So the state has a right to, you know, want to improve its quality and to regulate school and its education. However,
But if children of the foreign born if they're taught in their own language, won't they become hindered from becoming citizens? Isn't that the reason, the rationale behind this statute?
yes, but that's.
Don't back up.
Okay,
Don't back up.
Do you want me to fight how they rolled, or do you want me just to fight you?
You can fight me.
Okay. Okay. Hold on.
You know what, I'm gonna let you think about that, and let's hear from the state's attorney, Laura.
Okay.
Professor, I would just add to.
Ask for them.
Excuse me, I would add to what counsel said.
Oh, you're gonna help counsel?
Yes.
Oh,
Is
go
that
ahead,
okay?
go ahead.
Okay.
You can do that.
Relative to your assertion, Professor, relative to what was brought up in I think what you were asking was the state's interest in promoting
Right.
that the children get indoctrinated, for lack of a better term,
Sure.
to American society before the native tongue of their parents.
Mhm.
So the issue, what I saw as the issue here in Maya versus Nebraska was that there was a question of the means that the state adopted, and that the Supreme Court felt that they exceeded the limitation.
Okay, we're the court right now, though. So if you're helping her, make an argument for the teacher here.
Okay. I would say that I would concur with what counsel said relative to having the ability and restricting liberty. State's interest can't interfere with the liberty to teach the child.
And Nicole, you wanted
Well,
to say something else?
You had said something to the effect of children can't be a citizen, or it would impede them to become a citizen because they know a different language. And if anything, it would help them in this situation, because in this country there are people who speak other languages. There are jobs that are offered to people who know other languages. So if children are able to learn another language besides English, it will only help them to excel in the long run in their future. So that if they only speak English, then how is that going to help other people who are immigrants who came to the country and speak other languages? Shouldn't other people who come to this country knowing only other languages be able to communicate with people in the future as well? If we only treat the children now to, you know, only
So
teach
let me
them
ask you a question also. So in representing Maya, the teacher who was actually criminally prosecuted, are you also making an argument, it sounds like you are, for the family as well?
I'm making an argument for him to be able to teach the children. So I guess in a way I am kind of arguing for him and the children and the family as their right to be able to, you know, have a different language, to be able to excel, to be able to communicate with other people in the future. However, my client shouldn't be criminally charged for helping them to excel.
In looking, and I hear you and agree with you that both the teacher and the family does have a 14th Amendment right here. But I don't see that it's so fundamental that the state can't have some, you know, reasonable purpose for this statute. And unless the statute is really arbitrary, I don't see a reason for finding the statute unconstitutional.
Well, the statute should put into place where their primary language can be English. They need to be able to communicate in this country. That's what we speak. So you need to be able to be fluent in the English language, to be able to think in the English language and things like that. However, they should be allowed to have a secondary language.
Can I read you something actually from the lower court and from the Nebraska Supreme Court?
Yep.
And ask you, and maybe any of the other family practitioners here, your thoughts on it. The legislature had seen the baneful effects of permitting foreigners who are taking residence in this country to rear and educate their children in the language of their native land. The result of that condition was found to be inimical to our own safety. To allow the children of foreigners who had emigrated here to be taught from early childhood the language of the country of their parents was to rear them with that language as their mother tongue. It was to educate them so that they must always think in that language, and as a consequence, naturally inculcate in them the ideas and sentiments foreign to the best interest of this country. The statute, therefore, was intended not only to require that the education of all children be conducted in the English language, but that until they had grown into that language and had become a part of them, they should not in the schools be taught in any other language. The obvious purpose of this statute was that the English language should be and become the mother tongue of all children reared in this state. The enactment of such a statute comes reasonably within the police power of the state. Now, counsel, if you could, tell me why this court, the U.S. Supreme Court, should not agree with the reasoning here of the Nebraska Supreme Court.
You want me to, okay.
Can I ask
Me?
Sorry, can I ask a
Yeah, are you gonna go off the record?
Yeah, off the record for sure.
Okay.
When we're thinking about this stuff, should we
Yeah.
be considering the time frame of the case or?
Yes, yes, yes. So we're back in I'm sorry, 1923 when it was
Okay.
decided, yeah. And then we'll, you know, when we do our discussion afterwards, we can talk about that, yep. Oh, Amanda,
I'm going to bring
go
up the
ahead.
point that the statute unreasonably interferes with the liberty of the parents in guiding in direction of the education of their children.
Mhm.
It is too much control on the parents' right to educate their children how they see fit. This is a private parochial school, so it's also has the religious component as well.
Mhm.
And the statute directly interferes with the rights of the parents to have a say in how their child are being educated.
Thank you, counsel.
I have a quick
Nicole?
question to add on what she said.
Sure.
Now, where it's a private school, it didn't say anything about them being paid. Are the parents paying the school to educate their children?
Does that matter, counsel, in terms
Yes.
of what your argument is?
Yes, because if the parents are paying the school to educate their children, then they're consenting to what's being taught at the school. A public school is just a general school where all children go and they have to learn because the public school is governed by the state. However, if it's a private
Should
school.
this court decide differently depending on what you're saying right now?
Yes, because people are paying for it to be a private education. It's not a public one where it has to be regulated by the state. If it's a private education, then it should be where the parents have the right to educate their children the way they want to, and the
But-
children.
Go ahead.
And the children should have a right to be educated by people like my client who are just following what was supposed to be done. It's a private school. It's private. It's not governed by the
You
state.
would agree, however, that the statute is not going to be overturned unless there's an arbitrary, unreasonable relationship, right, to some purpose within the state's police power. So the test nevertheless is the same, because you're examining the 14th Amendment right of your client, you know, as well as the family, no matter what, whether it's public or parochial school. But I hear you on the distinctions too. Okay, so earlier I said I was going to come to Laura, the state's attorney. Let's go to her now.
Okay, hello, I'm representing the state of Nebraska today. Chapter 249 of the statute, while parents do have the liberty to choose their child's education, the state does have a responsibility in terms of ensuring that the children go to school, that the children receive.
What exactly is the state's interest here?
The
I mean, I articulated what I thought it might be when I was asking, you know, counsel for Meyer, but I want to hear you.
The states have a very specific interest, as I've outlined in the statute, that the children are taught primarily in the English language up until the 8th grade. And the reason for this is that they have a very limited capacity to learn during the day, and they need that.
But why
focus.
should the state interfere in family matters? Counsel for Meyer has said that parents want their children to be educated this way. Why should the state interfere and intrude in something that should be the realm of the family?
The state still has a responsibility to ensure that the children of the state are educated. If you consider homeschooling, there still needs to be testing done at the end of the year to ensure that the children is on track. Parents can't just take the child home and homeschool them without certain checks and balances in the system. And having English taught as a primary language is a check and balance in that same system. And it's really important because they need to learn the English language and then to think in the English language. And through the research that we've done, we've estimated that that's through the 8th grade that they've successfully completed that before they can take on a second language. This helps them in their futures and not just remain immigrants within our society, but then become the next generation in our country, to become citizens and think in this language and have American ideals.
My concern is, you know, that slippery slope we might enter into, should we agree with the state and the state having, you know, more control over family life in the future. One of my colleagues made the analogy with ancient Greece, and he said in order to submerge the individual and develop ideal citizens, that Sparta, what Sparta used to do, you'd take the, just the males, at 7, and entrusted their education totally to these official guardians. They didn't know their family at all. And I'm just worried that the more control the state has over family education matters, would we arrive at a, you know, police-like state here as well?
Well, I think English is the, you know, obviously the language of the country, so it's not really taking them out of the realm of what our society is. And this does not prohibit anything that happens in the home or after the school work day, but when you look at how long a child can focus on something during the day to ensure that they maximize their education, it really does need to be in English so they can get that baseline. You know, if you think about reading, writing, and arithmetic, this is one of the basics, and it needs to be done in English so we can maximize our time.
So how is the statute reasonably related to some legitimate state purpose? That's the test, isn't it? Is
Yes.
the statute reasonably related to some legitimate state purpose?
I'm gonna go off the record. I think it's to property.
I'm sorry?
I think it's to property, but I can't answer that question.
Well, you would agree that, would you agree at least that both Meyer and the families here have a 14th Amendment right?
Yes.
Okay, so regardless if it's life, liberty, or property, their rights are not so fundamental that that it would be very difficult for the state, you know, to overcome and to prove the statute's legitimate. You just have to show a rational relationship, correct?
Correct.
So what is it? What is the rational relationship here?
To the rational relationship to the benefit of the state and having these children be able to participate as future adults in society, being able to speak the language and properly communicate.
A
that way.
homogeneous society.
It doesn't mean that they can't have other skills, but their basics need to be in English so that they can pay their bills and speak to their doctors and, you know.
And therefore you have the right, you're saying, to prosecute someone like Maya who will not teach in the English language to these
Yes.
children.
Yes.
Nicole, do you want to rebuttal? Are you finished with your argument?
To me, there is no harm in teaching a child a different language. In the long run, it'll help them excel and will be able to communicate with other people who do come in the country who do not speak English. I don't see the harm in the parents allowing the teacher to privately teach their own children a different language if they consented to it. So.
Anybody want to ask them, either of them, any questions before we deliberate? Thank you both for volunteering. Okay. See if I remember everybody's name. This is Michael, correct? John?
Joe, I'm right here. I don't know if I'm on your official roster.
You're Joe. And you're John. John, Michael, Joe, Stephanie, 2 Amandas. Todd is our online person, and Jim is hiding and sick. All right. So who wants to start? Just, let's just examine what we just heard. And talk about first the nature of this right that flows from the 14th Amendment. Michael?
Well, actually, I was gonna just make a comment about the language thing.
Right.
I didn't bring it up because it wouldn't really help the state, and I'm on the state, but it was interesting how they didn't exclude old classic languages like Latin.
Correct.
And Greek.
Correct.
It was just, modern foreign languages that they seemed, that they took as a threat. I just thought that was
Exactly.
interesting that,
Mhm. And-
because they were sort of dead languages, they were sort of dismissed as being a threat to the American.
Exactly, because they wouldn't be the language the child would be conversing in, and then as a result, not learning English and American ideals and so forth. Yeah, yeah. So, where are we at? What is this 14th Amendment right that this teacher has to teach? Nicole and Natasha?
Would it be liberty? I mean, the liberty to be able to teach?
Absolutely, but what is the nature of that right? Is it absolute? Is it fundamental? And we'll explore that a lot in what does fundamental really mean. Because if it's such an important right, then it should be more difficult, right, for the state to overcome. Now, the state only had to show, and didn't, in terms of the opinion itself, a rational relationship for the statute with its purpose. Its purpose being to bolster homogeneous ideals, to make good citizens out of these children, American citizens, and for public safety, etc. So state loses, even though the nature of the right, isn't that basic, isn't that fundamental, right? It's 14th Amendment right, but it's not in the 14th Amendment, correct? It's how the Supreme Court has construed these rights to be in certain situations. By the way, there's a famous quote in here that you see quite often when family advocates are arguing, and it's almost like a little list of family rights. The right of the individual, without doubt it denotes not merely freedom from bodily restraint. So the court is expanding the definition of liberty and says, again, it's not merely freedom from bodily restraint, but also the right of the individual to contract, to engage in any of the common occupations of life, to acquire useful knowledge, to marry, establish a home, bring up children, et cetera, et cetera. So this sort of list of family rights that have been included in this definition of liberty, this liberty right within the 14th Amendment. Very famous leading case, notice how old it is, still cited today by courts, by judges, by family law advocates for the freedom of the family to decide what's best for their kids, which it wasn't even a family case. Teacher was prosecuted in a criminal case. And so in terms of the specific holding of the case, it had to do with, Nicole represented Meyer, the teacher, who was criminally prosecuted. But as a result, the Supreme Court and then, other courts later on have expanded it into a leading family law case for the notion, for the rule that the state should leave the family alone, shouldn't, as simple as that, shouldn't interfere in certain matters of family life, because again, under the 14th Amendment, liberty right of parents to rear their children, the state shouldn't interfere unless they can show some kind of rational relationship. And we're talking about who's had common law in here? I'm not a common law expert, but we are now talking about substantive due process. Later on next week, when we get to the Galt case, you look at procedural due process. So this is the substantive due process rights of the family, to have the state not interfere in matters of choice, regarding their children. even though, as I said, it was a case that dealt with, a teacher's rights, but the teacher's right was expanded to include the family, as well. So, now notice that the next case was decided almost in the next year or so. Pierce v. Society of Sisters, and that case actually cited, Meyer heavily in its opinion. So let's do the same sort of thing, and let's have one of the Amandas. Either one?
I can try it.
You can try it.
Yep, when I did the notes though, I kind of just wrote like my
That's-
argument for the family.
Okay.
So what exactly?
So you're
just give
representing
it-
the schools here?
The schools, okay.
Yeah, and then, who wants to,
I'll do it.
Governor, Michael? Okay. And Michael, your side is actually the appellant here, so you'll start first.
Sure. I'm representing Walter Pierce, the governor of Oregon, in the state of Oregon, in two cases. One by the Society of the Sisters of Holy Names of Jesus and Mary Sane, and the Hill Military.
So what is the statute that this court is looking at to construe here? What does it provide for?
The statute that's on issue here is the Compulsory Education Act, which mandated that children between the ages of 8 and 16 attend public school
Correct.
in Oregon.
Okay. Mhm.
And in the lower court, there was injunctive relief.
So these schools applied for injunctive relief in the lower court?
Yeah,
Okay.
to stop the application of that law because they're private education corporations, and didn't want to be fined with a misdemeanor fine for educating children that in a private manner instead of a public manner in violation of the act.
So what is the nature of the state's interest in this particular statute?
Well, the state
Where all
has an
children
interest
should go to use-
in ensuring that children are educated, and as citizens of the state, it's the state's responsibility and duty to provide for education for the children, and Oregon feels that the best manner of doing that is through public education that can be regulated by the state and subject to state mandates to ensure that the children are being educated.
So how is this, if we found for you, would we necessarily be overruling Meyer v. Nebraska? Can it be distinguished at all from this case? I mean, don't we have to follow the ruling of Meyer v. Nebraska and find for the schools?
Well, the state's position is that would be individual family claim, not a claim by a corporation. That a family may be protected under the 14th Amendment on how to educate their children, but corporation isn't.
If this court finds this statute is constitutional, that means then families will never have a choice of sending their children to private school, correct?
Well, there
So
are
it
some
doesn't necessarily-
exceptions. There are some exceptions that are allowed, children that are not normal,
Correct.
who have completed 8th grade, or whose parents or private teachers reside considerable distances from public school. I mean, so there are some exceptions in the act that may allow for private education of a child if the family wishes for that. The issue here is that these corporations aren't entitled to the protection of the 14th Amendment. They're not people, they're corporations.
Don't they have a property right?
Yeah, I mean, they're entitled to own property. They just may have to seek other uses for the property than violating this act.
If they do fall within the 14th Amendment's, property inclusion here, aren't they also, again, necessarily raising the rights of the family, as the liberty rights of the families as well, the families that they how do I say it, involved in the school systems.
Sorry, could you say that again?
All right. I think you're agreeing with this court that the schools do have some 14th Amendment due process right, and it has to do with the nature of a property type claim. And in so doing, even though their parties and families are not, aren't they somehow implicitly raising the rights of families to send their kids to these schools, the liberty rights of parents?
Well, yeah, perhaps, but, you know, it takes away from the regulation of the state to ensure that the children are receiving quality education. We don't know, the state has no control over what standards are being used in this private education, and so anyone could just sort of open up this school and could be failing to educate the children of Oregon to an appropriate level to ensure their ability for life and the pursuit of happiness and to be a model citizen in this country. You know, I mean, essentially, as a corporation, we would argue, you know, we would agree that they are entitled to own property, but they still have to follow the law as far as how they use that property. You know, they can't be doing illegal activity, which we feel educating young children in a private manner at this point would violate the act of the past to protect the children.
I agree with you that the education of young children is partly the mission or the duty of the state, but it is also partly or maybe wholly or more the responsibility and duties of the family making a choice.
Well, and that's why the state's position is that individual families should be the ones pursuing this matter, not the corporations. There are exceptions in the act that allow for families to choose how to educate their children. You know, they can choose to homeschool their child. If their child has special needs, there are exceptions that have been made to allow for specialized education beyond public school, beyond what's provided in public school. So the families would need to seek an injunction, not the corporation.
Thank you, counsel. Let's see from schools counsel.
So, even though the school is a corporation, we still have the right to own the property, and we are complying with the regulations requiring that each child from the age of 8 to 16 be schooled, which we are, but it should also be their right to attend this private school, whether or not, hold on, let me compose myself. Even though it's a Catholic school with some religious aspect to it, they're still learning normal, everyday education that any other public school would be providing to a child of the same age. I guess is what I'm saying.
I hear you, counsel. What else?
I think that having a law like this would interfere with the parents' individual rights to raise their children in that manner. These parents choose to send their children to a private school, you know, in a sense potentially hoping for a better education with the aspect of the religious education that going along with it.
Would you agree, however, that the schools have some right to regulate education, and that really the state's interest is in general public welfare, and, you know, again, the education of the young sort of, you know, equally, and that the state should have some sort of control over what's actually taught to children that will become and are American citizens.
I do agree with that, but I also agree that if the family decides that they don't want to have their child go to a public school, they should be able to have the choice to have their child sent somewhere else, with the same outcome of their children being a good citizen, growing up, good moral upkeeping.
Let me ask you, are you challenging the state's directive that all children must attend school? What exactly?
I guess that's what I'm challenging, that all children must attend public schools.
Public schools, okay.
I think that we should have the right, and each family should have the right to send their child to a private school if they wish.
Any rebuttal? Okay.
No.
Anybody want to ask either of the attorney's questions?
But aren't they basing their whole stance on profitability for their private schools instead of
Just
freedom?
asking you
I'm sorry,
profitability.
say that again?
Aren't you basing your argument on profitability of your schools being drained instead of freedom of education or freedom to pick a school? Isn't it all about the bottom line is profits for your client? No?
I guess you could say that, but in the same sense, like, saying that each individual child has to attend a public school, that's obviously taking business from my clients.
Mhm.
When they
That's
they
what-
should have the right to choose. So, I guess.
Who has the right to choose?
The
So we're
parents
talking
should-
about parents have the right to choose, but that would, the question had to do with the profitability of your clients, the school's property rights. Correct? Is that's what you're
Yeah,
getting at?
that's
Mhm.
fine. Yeah.
Mhm.
I guess, I'm not sure. Like, when I did it for the parents, so, well,
Our client has a right
Go
to
ahead.
have a business, has a right to have a school.
Yeah?
This act unreasonably interferes with our client's
Right to conduct a
right to
school, a
conduct
private school?
Private school. Because if everybody has to go to public school, then we'll be out of business.
Of course, that was, back then, private schools were like, now it's, while there is some control, it's been a coup for family rights. Stephanie had her hand up in the.
Yeah, representing the state, question is, is there a distinction between the qualifications of the instructors at the private school as opposed to the public schools? We have standards with our public schools, and it has been noted that the private schools do not meet all the same criteria at times. So therefore, that child is not being given the appropriate education by the instructors at the same level.
We feel that our client gives a better education in our private school than they would have in public school because they are receiving the core subjects plus religion courses as well.
But isn't it true that some of the instructors, they do not have the same equal credentials as with our public schools? But yet they're teaching the same subject, so.
Well, going to that question, I mean, there is a difference between private and public schools, so there may be certain criteria.
I think what the judge is asking here is, and she's directly going into, again, the state's right to regulate schools so that all the little citizens, the children within the schools, get a fair and adequate education. And in so doing, the state is able to, regulate more, obviously, the public schools than the private schools. And perhaps it could be that the qualifications of some of the people in the private schools maybe don't measure up as well to the qualifications of some of the people in the public schools. So the state does have a duty here, not only responsibility, but, a duty to children that they be educated.
But then it goes back to the parents' right, to choose
Sure.
where their child goes
Yes,
to school. So you have
absolutely.
that conflicting.
We would argue that, in part of the exceptions that are allowed under the act, you can request a special permit from the county superintendent. And perhaps, the organizations could seek for that permit to be able to educate the children in a private manner rather than public. I mean, the act is intended to ensure general education of the children of Oregon, and there have been exceptions made within the act to allow for special circumstances. And I would argue that, as in any other business that may be subject to some sort of regulation, you may have to apply for some sort of permit, like a building permit, or this is an education permit from the superintendent. So that would ensure that if you could show the superintendent that you're able to provide a quality education that would be equal to or better than what they would receive in public school, you should be able to still operate your business and maintain your property by keeping your revenues.
One more comment from Nicole.
Okay, I'm going to base it off of my fellow counsel with the right of the children to, be educated by whoever. The case specifically says that the fundamental theory of liberty upon which all governments in this union repose excludes any general power of the state to standardize its children by forcing them to accept instruction from public teachers only. The child is not the mere creature of the state. Those who nurture him and direct his destiny have the right, coupled with the high duty, to recognize and prepare him for additional obligations.
And that's basically it. Then that's the Supreme Court's, magic language. You see that quote often in both juvenile and family law. The child is not the mere creature of the state. While the state does have obligations, does have duties, does have responsibilities, again, just like in Maya v. Nebraska, let's leave the family alone. Okay, we're not challenging that children shouldn't go to school at all, but children certainly should go to some school. But the parents, again, and teachers and schools, with this 14th Amendment, liberty/property right, have the right to make those choices, and the state doesn't have a legitimate connection here, to its purpose of going to school. Again, at that time, 1925, how many private schools were there? Today, and while, again, just like Maya, very old case, but just in terms of the general proposition and the ruling about 14th Amendment rights of parents versus the state, you see it cited often in family court, juvenile court, memoranda, appellate briefs, etc. So far we've got 2 wins for the family, okay? And again, I kept harping on it, the nature of the right, because now we're gonna look at something a little bit different with Sarah Prince and her rights. I'd like to just talk about her first. And who is she? What is the nature of, what type of case this was? What's the nature of her right that might be different from, the parents in schools in Meyer and in Pierce? Todd?
This case involved a religious right,
Yeah.
rather than just
So
a right
far,
to education.
go ahead, Todd. We were looking at 14th Amendment, Meyer and Pierce, right?
Yeah?
Okay. Now we've got Prince. What's the nature of her right? What constitutional right are we talking about?
Freedom of religion.
First Amendment. And it's also 14th Amendment, because she's also the legal guardian and the parent that's arguing that, she's got the right to do what she thinks is best in terms of her children and the child that she's guardian of and so forth. So you would think at first, because she's got double the rights of the parents in Meyer and Pierce, that she would win as against the state. But different, right?
Mm-hmm.
all right, so something different happened here. So what was the statute that she, again, another criminal case, so far Meyer, it's family law, juvenile law, and yet they're criminal cases, Meyer, Pierce, Prince, another, criminal case. So what, Stephanie?
No child under, male child under 12 and no female child under 18 can sell publications, magazines, periodicals.
So what
in
type of
public.
statute are we talking about here?
It's the child welfare protection so that they won't be exploited.
Child
Child labor law.
labor,
laws,
right?
labor laws,
Yeah,
sorry.
yeah. The other two cases, we were talking about education, right? Tell me about what we know about Sarah Prince and her religion, Todd. Religion.
Well, the elders of the religious group here, in this case, the Jehovah's Witnesses, was getting her to be on the street with other members of the religious organization and sell magazines from the Jehovah's Witnesses. Magazines and things relative to information, to disseminate information from the Jehovah's Witnesses, publications of their religious group. And so it intersected here, as I see it, with the right of freedom of religion and the state's right relative to prohibiting child labor. It encompassed the child labor issue, as I saw it.
And because it's Sarah Prince that's the party and not her, what was the child's name? I always forget.
Betty
It's Betty, right?
Simmons.
Sarah Prince that's asserting her rights, correct?
Her last name, correction, her last name is Simmons.
Betty
sorry?
Simmons, and
It's
then
Betty Simmons.
Betty was the child, yeah, because she was the guardian, she wasn't the mom of that child. Sarah Prince is asserting her right to practice her religion and her right to bring up her child the way that she pleases, et cetera, again, the general 14th Amendment right. So why is it that Supreme Court, almost 20 years before, finds for the families in Meyer and Pierce, does not find for the parent in Prince v. Mass? How would you distinguish Meyer and Pierce from the Prince case? John?
Is that what you talked about earlier, with substantive rights versus procedural?
No, because it's still substantive
Still
due
substantive.
process plus First Amendment. So remember here we talked about in Meyer and Pierce, the state had to show rational relationship, right? Very sort of low kind of burden, but the state still lost, correct? And there again, parents, families, teachers only had this nebulous kind of 14th Amendment, right? We can do whatever we want with our children, the state shouldn't interfere. Again, the nature, if you compare the nature of the family rights, Sarah Prince has a greater, more fundamental right because it's included with the First Amendment, yet she loses. Why is it, and Michael's gonna tell us, I think.
I hope. Well, I think in Meyer and Pierce, you had families fighting for what I think the court would consider an important right for the children, which was their education. And in the Pierce case, you have a family that's fighting to protect their rights on something that the court would see as contrary to the best interest of the child, and that's, this labor law issue. So, I mean,
What do you mean by
I think
this
the
labor law issue?
Well, I think the labor thing here, probably fairly minimal. Could be a lot worse. They could be doing far worse labor that would be more potentially dangerous to the child's well-being. But
Did you say that again? Dangerous.
dangerous to the child's well-being. I think going door to door selling magazines is probably minor on the broad scope of things children could be doing. But if they open the door by allowing this, now you have kids that maybe are working in factories on, I don't even know, it's 44. So yeah, they could be doing factory work or something that's far more dangerous. And so the difference is, Prince has sort of the same rights, but they're fighting for something that's not something that the court necessarily sees as an important right for the child to allow them to work, that, they feel the child should be a little more protected from having to be put to work. Whereas with the education, you have families fighting for something that the court sees as a good thing for the kids, is their education. So I think that might be the distinction.
Okay. And
Just to agree and add, it's more so about becoming a martyr. In their religious practices, Jehovah's Witnesses are known as people who will basically risk all, and their duties was to give out the pamphlets in exchange for a contribution. So I guess what the courts is basically saying is that it's okay for a parent to want to put themselves at risk, but it's not okay to put a child who hasn't reached the age of accountability to make their own decision about that, and that's where it breaks and violates the labor laws.
And by the way, where the state in Meyer and Pierce only had to show rational relationship, because this was a fundamental religious right that Sarah Prince was talking about, in order to uphold the statute, what would the state have to show? And did. It isn't just rational relationship, right? Because Sarah Prince had more than just the 14th Amendment right. Yeah.
I'm going out on a limb, but maybe that it was closely tailored to the group that it was looking to protect.
Even more, it's a compelling state interest. You might hear that term in later cases. So again, because the nature of the right.
The nature of
is
the right is
so,
to protect the child.
I'm sorry?
I thought the nature of the right is to protect the child, but in this case, the child is not being protected.
No, but when we're examining the nature, of, say, a defendant's right, or in the case where this defendant was being prosecuted under this state statute, right?
Okay.
Just like the defendants here that were prosecuted under this state statute and are arguing, you've violated this prosecution and this statute has violated my right to substantive due process. Again, the substantive due process, the state only has to show, well, you know what, there was a legitimate objective here from this, for this statute. Whereas Sarah Prince, suppose that she wasn't Jehovah, right? She still had a right. She still would have a 14th Amendment right. Hey, I know what's best for my kid, right? Still would be prosecuted as she was. Outcome would be the same, okay? But the way it would have been looked at would have been more similar to here. Hey, child labor laws have a rational relationship to, as Stephanie said, to protecting, the citizens of the state. But state had to show more to overcome and to have the court uphold a conviction. Had to show that it had a really compelling interest. And Michael said it when he said dangerous. Child welfare. And this becomes sort of the wellspring for what later on when we get into the camp protection cases and how the state, in cases where children are in some kind of danger, be it emotional, be it physical, be it sexual, etc., that the state has this interest to interfere in family life. So again, in spite of the fact that the state has had a larger sort of hurdle, right, in Prince v. Mass, because it was child labor, and also a bit of history, think of it, at that time you also had the unions. Right? Why should kids be working when you have adults that are out of work? I mean, granted, what was she doing? She was distributing magazines. By the way, we're going to look at it, and I think we're going to have time for Yoda, or at least to get into Yoda a little bit. Look at the way, and later on there are other cases that deal with Jehovah moms and dads as well. The way the Supreme Court talks about the Amish faith, versus the language. If you just go back and read the two cases again, Prince and Yoder, and the way, just the language, the characterization of the two faiths and the parents in those cases, it's very interesting to see, you know, the differences. Somebody had their hand up as I was talking about.
She did, and then
Whoever.
Okay, I have a quick question for you. Now, I'm thinking more on the DCF side of things. If the child were placed in a pre-adoptive home where they were supposed to...
You were jumping so far ahead, but that's all right. Go ahead.
If the child were to be placed in a pre-adoptive home where the family says, yes, I want to adopt this child, and they're just waiting for the date from the court, yet the child is still considered a ward of the state through DCF because DCF technically has that guardianship custody over the child, the legal custody of the child, but the pre-adoptive parents also have that right. Now, the pre-adoptive parents are Jehovah's Witnesses and they have that child outside. Does the state have more of a right now?
You will see later on, there's so many distinctions here. Now, when you're talking about pre-adoptive foster parents, they almost have no rights.
Mm-hmm.
What they generally have is more of a contractual right with the state. Because in the cases where the state does step in and take custody of children, that means the state, and you'll see this term, and I think, I forget which one of these cases starts using the term parens patriae. The state becomes the parent. The state has custody. But of course, you know, where are the kids going to live? They're not going to live, who's the state? The state then places in a contractual sort of relationship children in foster homes and even pre-adoptive homes. And even, I mean, there are sad, sad cases of people that have, you know, loved very much children that they hope to adopt, and for one reason or another lose them. They don't have the same rights as the parents that we've just been talking about. But again, that's a discussion for way in the future, but I'm glad you brought it up. Anyway. All right. Stephanie?
I was just asking similarly, specifically with religions like Jehovah's Witnesses, they have they don't believe in blood transfusions.
Correct.
So
correct.
In this case, will it be similar where would it be against the law, or in that case would the parents have the preference, even though the child might die, would they have the preference?
And you'll see some of those cases, and we'll discuss them later on when we get into the care and protection, and also when we get into not only the family saying, you know, leave us alone, we don't want the state to interfere, we're speaking for the children. Then you have the state saying, well, the state has the duty and is speaking for the children to protect. Then you begin to see some cases where children should have, you know, a voice of their own to either say that, oh, I'm with the state because I want to be protected from this sort of harm, or no, I practice this religion too. I want to stay with my family. I don't want the blood transfusion, etc. So that gets into play later on as well. You know, when children begin to have a voice, and when I say a voice, you know, usually it's the cases where children, even the quite young, even the infants, have counsel, have attorneys. So let's just consider Yoder in the next 15 minutes. So Yoder is similar. Somebody tell me about. And so let's compare Prince.
Is there a marker
To
that
Yoder.
light's a little darker? That's so hard to see in these spots.
So I have Prince and Yoder.
Thanks.
Okay. So who are the parents in Yoder, Michael?
Jonas Yoder, Wallace Miller, and Aiden Mitzi.
And who are they? What, again? I'll sum it at the backs.
They're
In
Amish.
terms of- Mhm.
They live in Wisconsin.
Okay. And what?
You want me to do this one too? They don't want to send their children to high school.
Why not?
It's contrary to the Amish way of life. And they approved of their children going to school for the lower grades, but thought that they learned better skills, life skills and whatnot, after 8th grade.
Okay. So how would you compare the nature of the Amish family's rights here with Sarah Prince's right? Sarah, I mean Laura, I'm looking at you and saying Sarah, I'm sorry.
The court said that the Amish actually do it better than the non-Amish in terms of the real-life experience and training that the children receive once they stop.
What's the due process constitutional rights that we're looking at here again?
The 14th Amendment, the
14th Amendment again, like in the early cases, plus the first again. So in terms of rights, family rights, parental rights, identical to Prince. Right versus right, it's the same, right?
right.
Okay. So,
But where they diverge, I think, when you distinguish between them is the welfare of the child and the safeguarding of them, that the court in Yoder believed that the child's welfare wasn't at risk at all by not attending high school. In fact, it was preserved because they weren't exposed to material success and possessions and all of that in high school, and they were learning real life skills being at home, where in Prince, they thought the child's welfare was at risk.
so how is it that it's okay to accept totally from the compulsory education laws a child who is Amish? And yet, not allow a child to distribute booklets? John?
Because it's geared more towards education in Yoder, and it's geared more towards labor in Prince. And,
Well, again, but is it education, and compulsory education itself, such a compelling, legitimate state interest, yet the Supreme Court is now, and did, accept children, set up an exception pretty much to compulsory education, right, for Amish children. Joe?
Well, that 2 years of extra education won't necessarily have the impact on Amish children that it would on regular children, because Amish children are taught that labor-intensive focus is what they need, and that's really what's going to prepare them to survive in life. And the state's argument is that the Amish children need the 2 years in order to be able to survive out in the world.
Mhm.
And the Amish are saying, well, no, that 2 years is needed to survive in our world. They need to learn how to survive in our world.
Do you remember, how many know besides the opinion itself, anything about the Amish? Okay, Amanda and then Stephanie. Tell me what you know. Tell
So,
us
well,
what
I
you know.
actually buy a lot of Amish goods. They make
Okay.
a lot of baskets and stuff.
Mhm.
You really see them on the side of the highway, and I saw them one time in Mass, but it's a way of life. They live by the Bible. It's almost like Mennonite, and they abide by certain things. They teach their kids, even though they leave school, they still have another form of schooling on the land. And they get into things like farming, weaving baskets, craftsmanship. Occasionally, some of them do have automobiles, but it's a whole nother way of life.
And Stephanie?
What I know is that they have more of, strict rules about, being morally good, and they live, and based on simplicity. So the things that we would normally use and teach, their beliefs were totally opposite. For example, they're not gonna be into technology and, a speedier path of life, you know, the microwaves and the things of, that will
Even
produce.
heat or electricity.
Yeah. But in high school, it would be, it's, gonna be taught those fundamental things that they disbelieve. Those are the things that they would be learning, so which would be total contradiction to their style and their way of life. And furthermore, they teach their children, pretty much all the fundamentals at home. Their focus is, that the responsibilities is within the family, that family unit. And so the mom and dad take that role of being a teacher, as opposed to sending their kids off for someone else to teach them. They teach within their community.
Who else had their hand up? Did you, Todd? Oh, anybody else want to add to this? So here's a question, how is that, I heard that description, and obviously you've all read the case as well. How is that different from a lot of other faiths? Couldn't, what Stephanie and Amanda just said, couldn't it have been said about Jehovah's, or Protestants, or Greek Orthodox, or yeah.
I think the Amish have a better reputation for the application of their religion, better than the other ones you just named. They're
What do you mean by
hardcore.
better?
They're just more hardcore than anyone else. They
They like-
live a really strict life, and everyone knows it's not a
Their
joke.
values.
Like, everyone else that plays a religion card can be playing it for, to avoid persecution or whatever. But not the Amish. They're serious. I think people know that.
Joe?
And well, in the face of persecution and isolation and just being different overall, they've managed to thrive and survive for over 200 years.
They also live within themselves. I mean, whereas Jehovah's Witness, they interact in between.
That's-
So that's a major difference as well.
There's a lot of part-time Catholics. I don't think there's too many part-time Amish.
Oh, I know.
Yeah, Amish, you know.
Once they shun you,
Catholic when it's convenient.
Yeah,
That's what I
exactly.
used to tell my grandmother.
So in the last few minutes, let me ask you all a question. How many of you, I said at the beginning that I shorten a lot of cases for you, and you don't occasionally see a concurring or dissenting opinion, which I gave you dissenting opinion for Wisconsin v. Yoder. And why did I do that? Just because I wanted to give you more pages of cases, or? Why did
No,
you
I
do
mean,
that?
it's because, the dissent is looking to not just the rights of the parents, but the children themselves. And that
Where did
while
you see
many,
that? Go ahead. Yep. Mm-hmm.
Well, I have the whole long case right there. But while many do stay in the Amish way of life, not all do. And that there may need to be protections for the people that hate being Amish and want something different for their life. And, they could essentially be very far behind as far as, going to college or whatever, other life pursuits they may have if they haven't gone through high school. So it's more about protecting the children.
What did Douglas specifically say about children? Children's voice.
the child will be forever barred from a new and amazing world and diversity. In the future of the student, it shouldn't be the future of the parents. The child should have the right to decide.
Where the child is mature enough to express potentially conflicting desires, it would be an invasion of the child's rights to permit such an imposition without canvassing its views.
Parents had filed a motion to dismiss fairly early on as well, and Douglas mentions that this motion to dismiss asserted not only the parents' rights to bring up their children in faith, etc., but the children's rights as well, and you're all correct, but the famous quote is actually, I think the children should be entitled to be heard, he said. Entitled to be heard, and he cites what are some of the actual, at around the same time, notice this was decided in '72. This was like around the late '60s, '70s, you know what was going on in the US as well, was the what we call the constitutional rights of the child sort of era. Golf that you're gonna read next week, that was it still is the famous seminal case in terms of children's rights, right to counsel, to a hearing, to entitled to be heard, to Sixth Amendment right, etc. Even before that, there were some earlier cases, Healy and Galveston, Colorado, that were not necessarily juvenile cases because there was no juvenile court yet, but dealt with, young children being criminally prosecuted after giving confessions like through the night, and the court recognizing that those confessions might have been involuntary because of the differences of children and adults. But at the beginning, when I asked Michael who the parents were in Yoder, and you mentioned people, remember that one of the children actually testified, and one or two of them, right? And actually, then Douglas comments that what about Bernie and Yahtzee, I think was one of them that didn't, and Barbara Miller was another, and Douglas says, what if they want to go to high school? They're at least entitled to be heard. Doesn't mean that, because then it's still going to be the court considering the three. Remember I talked about the triangle. The family's rights, again, to bring up their children the way that they feel is best, plus religious, if there's a religious right as well. Also the state's right and duty to protect its citizens, but then finally the court also considering the child's right to be heard. This is what I want. I mean, that may not necessarily be what's best, and the court may not agree with that, but at least someone gets to hear it. They need to be heard, and that again, is still what's sort of the rule today. No matter what, they need to be heard. Later on, we'll talk about, counsel for the child and what our role should be. And in Massachusetts, it's very much client-directed. Though it might be an unpopular viewpoint, if the court doesn't hear it, that's just basically not there. And that's what I'll leave you with. I'll see you on Tuesday. Tuesday, right? Today's Thursday already.
Did you say we were getting assignments on roles? Oh, that you'll give us those on Tuesday to Thursday?
25.